The first time I heard the word competency hearing, I was standing at my own kitchen counter eating toast, plain toast, dry, the way I've eaten it since Margaret passed and there was no one left to remind me that butter exists. My daughter, Renata, had driven 2 hours from the city without calling ahead. She never calls ahead anymore. I've noticed that pattern developing slowly over the past year or so. The unannounced visits, the eyes that scan the rooms when she thinks I'm not watching, the way she opens the refrigerator under the pretense of getting herself something to drink and lingers just a second too long reading expiration dates. The way she walks through the house with that particular quality of attention that isn't love exactly, but something love can curdle into when it gets mixed up with fear and the wrong kind of advice from the wrong kind of person. She had a folder with her that morning, a real one, manila, with a clasp. She set her purse on the counter, she pulled out the chair she sat in since she was 9 years old, and she placed that folder on the kitchen table in front of her with both hands resting flat on top of it, the way people do when they're trying to project a calm they do not actually feel. I watched all of this from where I was standing. I finished my toast, I set the plate in the sink, and then I sat down across from her and waited. People who love you don't usually bring folders. She said she'd been talking to some people, that she'd been doing research, consulting with folks who understood these situations, that she was worried about me living alone out here on the property, that the house was a lot for one person to manage, that she just wanted to make sure I was being properly looked after and that my needs were being met. She said it all in the gentle, careful cadence of someone who has rehearsed the words many times and is concentrating very hard on not deviating from the script. I listened to every word without interrupting, which required more patience than I typically have in reserve, and when she finally finished, I looked at the folder sitting between us and I asked her, what kind of lawyers? She didn't answer that directly. She never does when the answer would cost her something to say out loud. She pushed the folder across the granite toward me instead. She has her mother's eyes. God rest her, 7 years gone this March, and I still reach for her in the mornings before I'm fully awake. But she has my stubbornness. I know exactly where it comes from because I was there for every stage of its formation. I watched it develop across 25 years of dinner table debates that I started on purpose, arguments I engineered because I wanted her to grow into a person who didn't surrender ground without a fight, who didn't accept the first answer or the loudest voice or the most convenient story. The world is not gentle with women who yield, and I knew that, and I raised her accordingly. I just never built into those lessons any provision for the possibility that she might one day turn that particular quality on me. Inside the folder was a document I had never seen before, a petition filed. I didn't call anyone that night. What I did instead was sit in the leather chair in the study, the one Margaret picked out from a catalog in 1991, the one with the brass tack trim along the armrests that she was very particular about when she ordered it, the one I have never been able to move or replace or get rid of because getting rid of it would require me to decide to get rid of it, and I have never been able to make that decision. And I read every word of that petition, all 3 pages of it, single-spaced, formal language arranged into paragraphs around a version of my life that I barely recognized as mine. I read it once, straight through, then I went to the kitchen, made a second cup of coffee, something I almost never do, and came back and read it again, slowly, with a legal pad on my knee, making notes in the margins of my notes the way I used to do when I was preparing a case and needed to understand not just what something said, but what it was trying to accomplish. According to the petition, I had forgotten appointments on multiple occasions, I had left the property unsecured, creating potential safety and liability concerns, I had exhibited confused and erratic communication in the presence of witnesses, I had demonstrated increasing difficulty managing daily affairs in a manner consistent with my prior level of functioning. There were other phrases too: diminished executive capacity, impaired judgment in financial matters, inability to reliably maintain personal safety protocols, the kind of clinical language that sounds authoritative until you hold it up against the actual facts it's supposed to represent and watch the gap between them. So let me tell you what it actually represented. I missed one dental appointment in April on a morning when the crappie were running on the east bank of the creek for the first time all spring, and I made a deliberate choice about how to spend my day. I rescheduled and went the following week, and my teeth are in fine condition, which the dental records Franklin later obtained would confirm. I left the back gate unlatched twice over the course of a summer, and I will admit to those, but the reason is one I won't apologize for. I still sometimes walk to that gate out of the muscle memory of 14 years of opening it for Sadie at the end of the day, and Sadie has been gone for 14 months, and grief is not the same thing as confusion. Grief makes you reach for what is no longer there without realizing you've done it. That is not a symptom. That is the ordinary, aching texture of loss, and it would have been nice if someone in this process had understood the difference. And the erratic and confused communication, that was me at Thanksgiving dinner telling Marcus Webb in specific and well-documented terms exactly why his suggestion that I consider liquidating the East parcel was not a conversation I was interested in having, had never been a conversation I was interested in having, and that my reasons were not open for further discussion. He apparently characterized this to Renata afterward as an episode of agitation inconsistent with my baseline personality. I would characterize it as being a man who knows what he owns and why he intends to keep it. The petition was thin. I knew that reading it. Taken individually, every item in it had a reasonable explanation. Taken together, assembled with the right kind of clinical framing and presented to the right kind of court, it could be made to look like something it wasn't. That is what lawyers are paid to do, and I knew that better than most because I had done it myself. I had taken thin cases and made them sufficient. I had assembled fragments into narratives and watched judges nod. I knew exactly how fragile and how dangerous thin could be. And then I reached the back page and I found the paragraph that made everything else in the document feel secondary. The petitioner respectfully requested that the court appoint a guardian to manage the financial and personal affairs of the respondent, including but not limited to authority over real property decisions, asset transfers, investment management, and estate planning instruments currently in effect. Real property, asset transfers, estate planning instruments. My house, my land, the 42 acres my father bought in 1959 for a sum that represented every dollar he had managed to save across 11 years of working in a steel fabrication plant, rising before dawn 6 days a week, eating his lunch from a pail, sending money home to his own mother in Alabama, and saving the rest with a discipline I still find remarkable when I think about it. He bought the land in cash. He cleared it himself over 3 summers with a second-hand John Deere tractor and 2 hired men from town. And when it was done, he stood at the edge of the Franklin and I have known each other for the better part of 30 years, and in that time, I have seen him in a wide range of circumstances: celebrations, emergencies, negotiations that went sideways, deals that came together at the last possible moment. And he has always been the same man in all of them: steady, precise, the kind of still that comes not from passivity, but from a deep and genuine confidence in his own judgment. He was 32 years old and sharp as a new blade when he helped me structure the sale of my manufacturing company. And in the decades since, he has become one of the finest estate and probate attorneys in this part of the state, which means that when I called him at 9:30 on a Tuesday night, he answered, he listened, and he said, "Bring me everything you have and come in first thing tomorrow." I was there at 8 o'clock. He read the petition across the desk from me in complete silence, the kind of focused silence that fills a room and crowds out everything else. His face gave nothing away. It never does during difficult information. It's like still water, perfectly flat, and it's one of the specific qualities I've always valued in him, because in a legal context, a lawyer whose face tells you how worried they are is a liability. When he set the petition down and looked up, he told me that the attorney of record on the other side was Craig Whitfield. He said the name with a particular weight, the way you say a name when you want the other person to understand it carries meaning. Whitfield, he told me, had built his entire practice around elder guardianship proceedings. He was methodical and experienced and patient, and he had an excellent record. He chose his cases carefully and prepared them thoroughly. Franklin looked at me steadily when he said all of this, with the particular directness he uses when he thinks I need to hear something clearly. I thanked him for the honesty. Then I told him what I needed him to understand before we went any further, because I needed my own attorney on the same page before we built anything. I told him that I am not confused, I am not diminished, I am not a man struggling with his affairs or his property or his own mind. What I am, specifically and demonstrably, is inconvenient to a particular man named Marcus Webb, who has been in my daughter's life for 2 years and who has, in that time, developed what I believe is a systematic and deliberate approach to removing me from the decisions surrounding this land. Marcus Webb has a financial stake in a development group. That group has been circling property in this county for several years. My east parcel, 40 acres of flat, accessible land with road frontage on 2 sides, would be worth a considerable amount to the right buyer, and Marcus Webb had tried twice, through Renata, to begin a conversation with me about selling it. Both times, I shut the conversation down completely. After the second time, Renata began mentioning, in passing, things she was noticing about me, concerns, small things, she called them, but they added up, she said. I believe those small things were fed to her one by a man who understood that the fastest path to my land ran directly through my daughter's love for me. That is not a symptom of anything except someone else's calculation, and I needed a court to see the difference between a man declining and a man being maneuvered. Franklin was quiet for a long moment after I finished. He had his pen in his hand, but he wasn't writing. Then he said, "How long have you known about the development group?" I want to describe the morning of the hearing carefully, because I have replayed it many times in the weeks since, and I want you to feel what it felt like to walk through those courthouse doors as the person on the other side of a petition like this one, which is to say, as someone who knows exactly what it means to be there and is determined not to look like someone who doesn't. I woke at 5:15, which is earlier than my usual 6, though I won't pretend the sleep that preceded it was especially restful. I lay in the dark for a few minutes, listening to the house, the way it settles and breathes at that hour, the particular creak of the floorboard in the hallway that I have been meaning to fix for 8 years and have come to think of as a companion. Then I got up, put on the kettle, and stood at the kitchen window while it heated and watched the east field come out of the darkness in increments as the sky went from black to gray to the pale, thin gold of early morning in November. The frost was heavy on the low ground near the creek. The oak on the south ridge was bare. I could just make out the shape of it against the lightening sky, and I stood there with my coffee and I thought about Margaret, the way I do most mornings, and I thought about my father, and I thought about what both of them would have said about what I was about to go do. Margaret would have told me to eat something before I left. My father would have told me to wear the good suit and not to let anyone in that room see me sweat. He was not a complicated man in his advice. So I ate, and I wore the good suit, the charcoal one, peak lapels, wool, the one I have kept in a garment bag at the back of the closet for occasions that demand the fullest version of yourself. I had worn it last to my son-in-law Thomas's funeral 7 years ago, and it had hung untouched since. But I knew when I woke up that morning that this was the day it came back out. I took my time getting dressed. I shined my shoes, which I haven't done in months. I stood in front of the mirror in the bedroom, Margaret's mirror, the tall one she kept by the window, and I looked at myself for a moment. Not out of vanity, but out of something more deliberate than that. I was making sure I recognized the man looking back. I did. I carried the leather briefcase my father gave me the day I passed the bar in 1978. Real leather, the kind that develops character over decades rather than wearing out, with brass clasps that still close with a satisfying solidity, and my initials stamped in the lower right corner in gold letters that have mellowed over the years to a warm, deep amber. That briefcase has been in more rooms than I can count. Negotiating tables, courtrooms, closing dinners, arbitration chambers. It has weight to it. Not just the physical weight, though it does have that, but the other kind. The kind of weight that comes from everything a thing has been part of over a long time. I set it on the passenger seat, not the back, the way I always used to when I was practicing, when it was still a daily object rather than a relic. Because here is the thing that no one on the other side of this had fully accounted for, and I want to be precise about this because it matters to the shape of what follows. Before I owned a manufacturing company, I built it from scratch across 20 years, starting with a loan I couldn't afford and a product I believed in when no one else did. And before that, before the business, before the land inherited and expanded and maintained, before the marriage and the children and all the years that followed, I spent 17 years as a practicing attorney. I graduated from law school in 1975, I passed the bar in 1978, and I practiced contract law and estate planning and probate work in Harrow County until the early 90s, when the business had grown enough that it needed all of me. I know the procedural architecture of a competency hearing from both sides of the table. I know what the petitioner needs to establish and where those arguments are typically weakest. I know what judges in these cases listen for and what makes them skeptical, because I have stood in their courtrooms and I have watched their faces and I have learned over years how to read them. I know the specific vulnerabilities in a petition that relies heavily on secondhand observation and motivated witnesses and medical opinions gathered without the subject's informed consent. Craig Whitfield was very good at his work, but he had prepared for a retired widower on 40 acres who might show up with a county-appointed advocate and a nervous expression. He had not prepared for this. Franklin and I arrived at the courthouse at 8:45. The clerk at the front desk glanced up and recognized Franklin, gave me a polite nod, stamped our appearance sheet. We walked down the hallway to courtroom 3 and stood outside it for a moment while Franklin reviewed his notes one final time. I stood beside him and didn't say anything. There was nothing useful left to say. We'd done the work. What remained was simply to go into the room and do it correctly. We walked in together at 4 minutes to 10. Courtroom 3 is smaller than I remembered it. I have spent a fair amount of time in that room over the years, and it always strikes me when I return to a place after a long absence how much the space has contracted in memory's absence. The ceiling feels lower. The light through the high windows is thinner than I recall. The room smelled the way courtrooms always smelled, paper and old wood, and something faintly institutional underneath, like the smell of consequence accumulated in the walls. Renata was already seated at the petitioner's table on the left side of the room. Craig Whitfield was beside her, mid-40s, well-made suit in a dark navy, the kind of unremarkable good taste that signals someone who dresses for credibility rather than impression. He had a yellow legal pad in front of him, and he was writing something in the margin of a document, his head bent, the posture of a man who is comfortable in this room and has no reason to be watching the door. He didn't look up when we entered. Renata did. I watched her face in the moment she registered me coming through that door, and I want to be honest about what I saw there, because it wasn't simple, and I don't want to reduce it. She had been building a picture of me in her mind, I believe, for the better part of a year, a picture assembled piece by piece from things Marcus had said and pointed her toward and framed for her in a particular light until it felt like her own observation rather than something she'd been handed. A picture of a man coming apart slowly, a man who needed someone to step in before it got worse, a man who one day, if not today, would become a danger to himself and his assets and his future. She had looked at that picture so long that she had stopped being able to see me clearly, and now here I came through the door of courtroom 3 in the charcoal suit with the brass clasps and Franklin Osai at my shoulder, moving through that space with the specific ease of someone who has moved through it before, and the picture she'd been holding didn't match what she was seeing at all. I watched it cross her face, not just surprise, but something more layered than surprise, something that might have been the first faint tremor of doubt about the story she had agreed to put her name on. Then Whitfield looked up. He looked at Franklin first, the quick professional recognition of two people who know each other's reputations, even if they haven't met personally. Then he looked at me. He held his eyes on me for just a moment, the way lawyers look at opposing parties in the first seconds, assessing, cataloging, and then he looked down at his file. I don't know exactly what was in that file, but I know what was in my background, and I know what it looks like on paper, and I know the moment when a man reads something that changes the geometry of the room for him. It isn't dramatic, it's quiet. It's a slight settling of the shoulders, a stillness behind the eyes, a pause where there wasn't one before. Franklin leaned close and said very low, "He just read your biography." I said, "Good, let him read it twice." I won't reconstruct every motion and ruling and evidentiary argument from beginning to end because this is not a transcript and you didn't come here for procedure. But I'll tell you what mattered, and I'll tell you how it moved, because the shape of it matters to the story. Whitfield had built his case around 3 medical opinions. They were the core of it. Everything else was scaffolding. The first 2 were based on cognitive assessments that had been conducted without my knowledge, arranged by Renata through intermediaries at appointments I had been brought to under pretext I hadn't questioned because I had no reason to question them at the time. Franklin moved to exclude both before we reached the first recess on the grounds of lack of informed consent, improper foundation, and the absence of any procedural safeguard that would normally apply when assessing a person who had not yet been adjudicated incompetent. He made the motions cleanly and with precision, without theatrics, the way he does everything. Judge Patricia Suarez, she was in her late 50s, compact and precise, with reading glasses she wore on a chain, and a manner that communicated very efficiently that she had heard every version of every argument likely to be made in her courtroom and was not going to be moved by anything except well-constructed facts, sustained both motions. Not reluctantly, efficiently, like someone removing obstacles from a path so she could see what was actually in front of her. The third opinion came from a Dr. Gerald Foss, who had seen me once for 12 minutes at what Renata had told me was a routine wellness check required by my supplemental insurance carrier for annual renewal. It was not. It was an arranged assessment, and I had not consented to it as such. Franklin challenged the foundation, and while Judge Suarez allowed the opinion in, the 12-minute duration of the examination and the circumstances of its arrangement were in the record, and I had been in enough courtrooms to know that a judge who allows something in is not necessarily giving it the weight the party who offered it believes she is. Then it was our turn, and I stood up. I addressed Judge Suarez directly, the way I used to address the bench when I was the one standing at the table, with the right measure of deference to the position and the right measure of confidence in the material, because a judge can tell the difference between a person who is performing confidence and a person who has it, and the latter is far more persuasive than the former. I told her I had with me the complete records from my physician of 19 years, Dr. Howard Blaine, including 3 separate comprehensive cognitive assessments conducted voluntarily over the past 8 months, full blood work, a neurological screening I had requested myself, and Dr. Blaine's written summary, which I submitted as an exhibit. I had correspondence from my accountant of 12 years detailing the consistent and competent management of my personal finances with no anomalies or patterns of concern. I had a letter from my financial advisor documenting 11 independent investment decisions I had made in. The petition was dismissed. Judge Suarez handled it without fanfare, without commentary, with the clean efficiency of a person who sees no reason to belabor what the record has already made clear. She thanked the parties, she gathered her materials, and she left the bench. Franklin shook my hand in the hallway outside with the warm, quiet satisfaction of a man who had known what was going to happen and had enjoyed watching it happen anyway. We made arrangements to speak later in the week about some protective legal structures we discussed: a comprehensive power of attorney properly executed, a healthcare directive updated and witnessed, some documentation that would make any future attempt at something like this considerably more difficult. Then he took the elevator, and I took the stairs, because I always take the stairs. I came out the front doors of the courthouse into the cold November air and stood at the top of the steps for a moment with the briefcase in my hand, just breathing. The parking lot spread out below me. The sky was the flat, even white of late autumn, the kind of sky that gives no information about what it intends to do next. A few pigeons were moving along the courthouse wall. An ordinary Tuesday afternoon in Harrow County, carrying on exactly as it would have, regardless of what had just happened inside. Renata was waiting at the bottom of the steps. She had her blue coat on, the long one she's had for several years, the one I've always thought suited her. She'd clearly already said whatever needed to be said to Whitfield, who was crossing the parking lot toward his car with his briefcase and the particular posture of a man recalibrating. Renata was standing with her arms folded, not in anger, I could see that, but in the way people fold their arms when something inside them is not quite holding together and they're trying to help it along with the pressure of their own hands. She looked like my daughter, not like a petitioner, not like someone who had spent the last several months building a legal case against the man who raised her. She looked like the girl who used to come and sit in the study doorway when something was wrong and wait for me to notice without having to say anything, because she'd always been better at waiting than at asking. I came down the steps, and we stood together on the pavement, and for a moment neither of us said anything. Then she started to talk, and what came out was not what I expected, which is to say, it was not defensive. She told me she really believed it, that Marcus had shown her things, a video she thought she'd taken of me being confused, though she'd describe it later and I'd identify immediately the context that explained every moment of it. That he had told her things, observations he claimed to have made over time, small incidents he'd cataloged and presented to her as a pattern, a picture that accumulated slowly until it felt like her own conclusion rather than something she'd been handed piece by piece by someone who needed her to reach it. She said she thought she was helping me. She said she thought she was doing what she was supposed to. The drive home took 40 minutes on Route 9, which winds through the low country past the creek bottom and then opens up into the long, flat stretch where the farms are, where the land spreads out wide and unhurried under the November sky. I had the window cracked despite the cold because I wanted the air, the smell of the fields and the dry leaves and the particular quality of cold that comes off standing water. I have driven that road so many times that the turns come without thought, the landmarks registering somewhere below conscious attention, the old Hendricks barn with the roof that has been going since the 80s, the grain elevator, the Methodist church with its changeable letter sign out front. Ordinary things, permanent things, the kind of things that hold their shape across years while everything around them rearranges. I turned up my driveway and the gravel shifted under the tires the way it always does, the familiar sound of coming home. I parked in front of the house and sat for a moment before getting out, just sat, with the engine ticking as it cooled and the briefcase on the passenger seat beside me and the late afternoon light going gold and then amber across the front of the house my father built on land his savings bought. Still mine. I went inside. I hung the charcoal suit back in the garment bag and put it away with the intention of wearing it again under better circumstances. I put the kettle on and sat at the kitchen table and looked out the window at the east field, the 40 acres that had started all of this, the flat, good land with the road frontage on two sides that someone had looked at and decided was worth more to them than my dignity. The frost would come tonight. I could feel it building in the air. The creek bottom would go silver by morning. The crossword from the day before was still on the table where I'd left it. I'd done most of it over breakfast yesterday, but I'd left one answer blank on purpose, a small private thing, a placeholder, something to come back to. 7 across, a legal term for mental capacity, 7 letters. I picked up the pen, I filled it in without pausing, without second-guessing, without any of the hesitation the other side had staked its case on the displaying. Then I set the pen down and finished my coffee and watched the light change across my father's land. My name is Walter Edmund Greer. I am 73 years old. I do the crossword in pen. I take my coffee black and I take my time, and I take no one's word for what I am or what I'm capable of without showing them clearly and on the record exactly what those things are. I have never, not once, left the stove on, and I have the documentation to prove it.